Starting a business is all fine and dandy until a problem arises with one of your partners. One of the major ways to deal with those problems when they occur is to have a comprehensive operating agreement to help your business. My name's Joe. I'm a corporate attorney at the Gordon Law Group, and I've helped countless business owners with their operating agreement for their venture. In this video, I'm going to break down 5 common mistakes that I see around businesses and their operating agreement. Problem number 1 that businesses have with their operating agreement: simply just not having one. You'll be shocked with how many businesses set up their company and don't have an operating agreement to help them resolve issues along the way. An operating agreement is crucial to ensure that all parties involved in the company know exactly what they're getting into. One of the major steps that every business needs to take is to draft an operating agreement that's tailored specifically to their business model. Problem number 2, having ambiguous or incomplete language within your operating agreement. The only thing worse than not having an operating agreement is having an operating agreement that just doesn't make sense. One way to ensure that your operating agreement does make sense and is moving your business forward is ensuring that all language in all sections of that agreement are clear and concise so that all parties know what they're getting into. Having complete information in your operating agreement is crucial for ensuring that your business succeeds. Mistake number 3, failing to acknowledge capital contributions and ownership. There's nothing worse than having your company start off on the wrong foot. One of the first steps that's needed to do is contribute capital into the business. Each owner should be contributing some form of capital into the business so the business is not undercapitalized. Every owner of the business needs to know, 1, exactly how much capital they need to provide, 2, when they need to provide it, and 3, the rights that they have in repayment of capital upon distributions to them. If one owner were to pay a substantial amount more than the other owner, that other owner's percent interest in the company would be affected. This leads to a potential dispute along the way. Number 4, lack of buyout and transfer provisions. Let's say one owner of the business wants to leave the company. They're done. They've done everything they wanted to do. Now they just want to get paid. What rights does that owner have? Can they sell the business to a third party? Must they offer their interest in the company back to the other owners? Can they assign their rights to the company to a third party? All of these aspects and all of these questions are crucial in determining what exactly you want the rights to be upon transfer. If there's multiple owners of a business, you may want to require the transferring member to allow the other owners to purchase their interest in the company prior to that exiting owner from leaving the company. This is to ensure that you're working with people that you actually want to work with, and you have the ability to control the business to the same extent that you did previously. Number 5, good old taxes and Uncle Sam. If you're an owner of an LLC that's taxed as a partnership, you're responsible for your share of income that the company produces. That is, if the company produces $10,000 and you're a third partner in the business, you have individual income of $3,300 that you must pay tax on at the end of the year. If the company were to not distribute any income to the partners and just leave all of the money in the capital account, the owners of the business could be liable for tax and not receive any income. Essentially, this means that the owners are paying to be an owner of the business rather than them getting paid to be an owner of the business. Having tax distribution language within an operating agreement is crucial to ensure that no owner is shocked when their tax liability comes to the year and they have to pay considerably more than what they received. If your operating agreement is not up to par, or you just don't have one, contact the attorneys at the Gordon Law Group, because we'd be happy to help. My name is Joe. I'll see you in the next one.